One, it says law made. Will it also apply to the power exercised by the legislature in terms of the constitution? One aspect. The second is, to the extent of incompetency,
Correct.
cease to have effect on expiration of period of 1 year
Correct.
after the proclamation cease to
Right.
operate, except as respects of thing done or omitted to have been done before expiration of that period.
Correct.
So what it also protects is whatever has been done or omitted to be done before expiration of that period
Correct.
will be protected.
Correct. Absolutely.
Will this not get covered in that part?
It won't, because this is an amendment of the Constitution. It's not a law.
Then you aren't contradicting yourself.
I'm not. It's not a law. This is not a law, Mullah. This is an amendment to the Constitution.
So what it talks about is laws, not
No, because you're a delegate of Parliament, of the legislature. In other words, whatever power the legislature has to make laws, you can make laws. Mullah's 356 is not an omnibus position to Mullah's take over the legislature and do what you like.
Mr. Sibal, when we interpret, we have to interpret the section without taking, you may say in the contextual interpretation, we have to take the whole background.
I'm sorry to say that's covered by BOMAI, Mullah. That's not covered. That's not. There's no cavil to it. That's covered by BOMAI, and I've cited all those passages of BOMAI to your lordships already.
Just one.
Let's not find any other power. That's non-existent. The temporary provision.
Second last year.
But BOMAI 153 4C.
Says, when we interpret, especially because your lordships interprets the Constitution, we only make arguments. It's for posterity. It's not for this case or that
Yeah,
case.
you don't have to remind us.
Your lordship knows that. If you give such a power to Parliament under 356, your lordships, anything can happen. Anything can happen. And as I said that the other day, and I'm digressing a bit. With respect to Maharashtra, I said, if Maharashtra is upheld, it will happen again. And it happened in Maharashtra itself. Because we have to protect the Constitution. We don't have to do anything more than that. Our at both sides, Mullahs, endeavors to protect the Constitution. And your lordship upholds it. That's our task. And upholds it for posterity, not for a particular case.
357(2) of the Constitution of India.
Yes, I will. Which was, I'm sorry, PDF. I got it, yes. Yes, I will. Has ceased to operate, continue in force until altered or repealed or amended by the competent legislature or other authority. That's right.
What's the difference between the two?
Difference is that is 1 year.
1 year.
That's only,
And protection whatever is
Yes, in other words, the
done and
legislature can
omitted to be
undo
done.
it. The legislature, means because it's been a delegate, before parliament is a delegate.
But in both the cases, it's law made and exercise the power of legislature.
Yes, absolutely. That if this is a law made, if your lordships believes it's a law made, then within 356, because 356 is to restore democracy and it's only a temporary measure. Right? And Malad, not only that, you cannot take irreversible action. That also is decided by this court. That during this time, unless your lordship knows the difference between state of Rajasthan and Bomai. In state of Rajasthan, they said, in Bomai, they said, you must dissolve after the proclamation has been accepted by both houses of parliament. You can't do it before. Until there's suspension, which is what I was saying yesterday to your lordships. Now, that's irreversible. Therefore, Bomai said you can't do it. Rajasthan said it's possible before approval. Bomai disagreed. That can only happen after approval. But here what happened? It happened before. And it happened without aid and advice. That's even worse. I could have understood if the governor has sent a report way back on 20th of June. I could have understood then. But not in this fashion. Therefore, the whole motive was political, and I've been saying that from day one. The motive was political, the process was political, but the end result was unconstitutional. And Malas, I've already pointed that out. Let's not take more time of the court. What did Malas Ambedkar ji say? He said, I cannot altogether deny that there's a possibility of these articles being employed for political purposes. So what I've said before your lordships is no different from what Ambedkar ji said. His fears have turned out to be right. So, Malas, therefore, now Malas kindly come to now come to the argument. I've done with Malas the dissolution part. I've done with 356. Your lordships have read all the judgments, Malas. I'm not going to repeat anything. Now I come to the argument of impossibility. An argument not raised, not part of the counter affidavit, not part of any pleadings, not part of any proclamation, not part of arguments the last time also, not part of the first set of written submissions, and yet we have to deal with it. Now, let me tell you also the principle of impossibility, constitutional principle of, I'll just enunciate it. If there is a constitutional obligation to be performed, and it has to be performed, then in furtherance of that constitutional obligation, the principle of impossibility of performing another obligation comes in. Give your lordships an example. The term of the assembly is 5 years. Assembly is dissolved in 4.5 years. There is no assembly. And the judgment my learned friend cited, there is a presidential election or election of the vice president, and members of assembly have to vote. But the term of the assembly expires in 5 years' time. The constitution says you have to perform that obligation. So if the assembly is in dissolution, it's impossible for them to vote. That's the constitutional principle. Where is the obligation under 370? It has to be stated in the Constitution. You can't silently invoke it. And 376 probably, 3 may, not shall. There is no obligation. That's the principle of impossibility, which has absolutely no application. How is it impossible, Malad? Why is it impossible? No, you've made it possible by acting that the way you've done. That's the way to do it, Malad. Now, whether that's constitutional or not is a definite issue. But it's certainly not impossible. If you uphold it, it's not impossible. If you don't uphold it, it's only unconstitutional. Beyond that, your lordships are not asked to decide. So where is the question of impossibility? That's my answer, Malad. And the judgment that my learned friend cited, Malad, what's that judgment? In the presidential election is exactly that. Namely, the election had to take place, voting had to be done, the assembly was dissolved. So how could they have voted? The proclamation was there. So that's the constitutional principle. That's it. Anything else? No. They have already. Very quickly, I'll take about 10 more minutes and I'm done. Now, kindly come to 272. Where is it? Page 27, PDF, page 27. Volume? Yes, my rejoinder, PDF 27. I mean, it's just, I've already argued it, Malad, that this is all beyond Malad, the powers of the president. And in any case, he has to act on the aid and advice of the Council of Ministers. So its Parliament also has nothing to do with it. And Malad, it doesn't need concurrence, doesn't need consultation. That argument I've already made. And if that can't be done, Malad, then we're left with nothing. Then 273. No, let's 273 now. But let's also kindly note. Nothing else. Oh, one second. 36. Well, let's kindly come to my the 367 argument that was made. The interpretation part. And then they relied upon Damnu, Malad. That argument has already been made. I'll not repeat it, Malad. Damnu itself says that this particular change at that point in time was not a change in the substance of 370. In the Jammu Kashmir constitution is applicable, the word governor was already there. And therefore, you couldn't have interpreted it in any other way. So that's all, Malad, it's already been argued. Now come to Malad to Article 3. PDF 33. Yes. So, Malad, as far as Article 3 is concerned, Malad, let's assume I've made my arguments on the proviso already, Malad, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that, Malad, all this is valid. Let's assume. Malad, how can they make the union, a state into a union territory? Under what provision of law? Okay, under what power? Then my Lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that? You can't use a power in 3, and of course that's not their case also. It's nobody's case that this was being done because of national security. Pulwama happened, Malaj, in February 2019 during the president's rule. And then they had elections in May 2019. And what is the justification of keeping, not constituting the state, Malaj, for 4.5 years? Under what constitutional basis can you say that I will keep a particular state as union territory for 4.5 years? You say you are going to have municipal elections. You're going to have local government elections. There are a number of the tourism has increased. So what's the impediment then? What's the constitutional logic, Malaj, or basis on the basis of which you can deny the people of Kashmir a statehood, which and Malaj, India is a union of states. As your Lordship rightly said, my Lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, Malaj, there's one last thing and then I'm done. I want to show you the annexures in this, Malaj. This is my argument on 3, Malaj. Others will deal with it in some form. I want to show just one. Yes, kindly see PDF 42. Now, this is dated 17th May 1949. But as your Lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar. And he tells Vallabhbhai, here's the draft. Jawaharlalji has seen and approved of it. Will you kindly let Jawaharlalji know, direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. 3rd November? Yes, it's very interesting with us. 3rd November. No, not 3rd November. No, yes, 3rd. Yes, where is it? Yes, yes.
But look at Sardar Patel's letter at page 47, 46.
46, yes. Correct. That's the draft, Malaj, of 306A. Kindly come to 244, Malaj.
Right, that's that letter.
Thank you for your letter of 15th, which I have received only this afternoon on my return from the Constitution. 1 second. I find there are some substantial changes over the original draft, particularly in regard to the applicability of fundamental rights and directive principles. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. I do not at all like any change after our party has approved of the whole arrangement in the presence of Sheikh Saab himself. Whenever the Sheikh Saab wishes to back out, He always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government or even on his personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is right thing to do, you can go ahead and do it. Now see the next document, 3rd November. There was some, again, this is by Vallabhbhai Patel. There was some difficulty about the provision relating to Kashmir. Sheikh Saab went back on the agreement which he had reached with you in regard to the provision relating to Kashmir. He insisted on certain changes of a fundamental character, which would exclude in their application to Kashmir the provisions relating to citizenship and fundamental rights and make it necessary in all these matters as well as others not covered by the accession to 3 subject to seek the concurrence of the state government, which is sought to define as the Maharaja acting on the aid and advice of Council of Ministers appointed under the proclamation on 8 March 1948. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, Malats, persuaded the party to accept all the changes except one. And of course, Sheikh Abdullah thereafter.
Sure, there was a political compromise to ensure
That's all.
enough flexibility at later point of
Absolutely.
time.
All I'm saying is,
But
everybody
there's
was
another
part of that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. Well, all that I'm saying is, Marat, they were all collaborating. The key players were collaborating in drafting 370, and this is how they understood 370.
That argument you have already.
Yeah, I've already made. I'm not repeating it, Marat. I just wanted to read these letters. So, Marat, and then I've got this table, Marat, of Jammu Kashmir, Marat, where Jammu Kashmir is ahead of most of the states in India in every parameter. But we are not concerned with that, Marat. I just put it. So that's all I have to say, Marat. I just want to say at the end that, Marat, as I said, Marat, your lordships, Marat, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Those people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this time.
Has to be accepted.
Excuse me for a while, but let's fill it up.
Mr. Subramaniam, you'd be arguing.
Yes, my lord. My lord, am I audible? Am I visible?
Both, Mr. Subramaniam.
Yes.
Thank you, my lord. My lord, I just want to make a few brief submissions on Article 370 in the light of your lordship's questions and observations. My lord, it might have begun as a temporal provision initially. I don't think anybody can dispute that people envisaged it as of temporality. But, my lord, the provision had adequate evidence, intrinsic evidence in its words to suggest that it could be there to stay. And that is what has happened. And my lord, this is the crux of the matter. Has it happened in a manner known to Article 370? my answer, my lord, is yes. In a manner known to Article 370, Article 370 stays. Now, my lord, how has this been achieved? As your lordships would notice, that it was a Constituent Assembly of India which gave the people of Jammu and Kashmir the ability to determine their political future through a constitution. The instrument of accession, my lord, did not completely transfer sovereignty, as held by Justice Gajendra Gatkar in Prannath Kaul's case. The instrument of accession itself had reservations that it was intended to abide by a future constitution, a future determination by the people of India, which is why Justice Gajendra Gatkar said that until the 1939 constitution was there, the Maharaja was still enjoying a certain kind of sovereignty to make laws, and therefore, my lord, upheld the law in question. Now, my lord, when does integration become complete is the question. And, my lord, in this case, unlike the cases of privy purses, unlike any other case, the sovereignty actually transfers from the king, from the monarch, to the people. And this transition from the monarch to the people is the common framework of both the Constituent Assembly of India and a Constituent Assembly to be formed. The notification of 25th November 1949, my lord, expressly uses the words Constitution as applicable, or insofar as is applicable, because that is how Article 306A of the draft Constitution presaged it. Well, on Article 306A is the only article which refers to the instrument of accession and refers to the matters contained in the instrument of accession as limiting the power of Parliament to make laws. Therefore, my lord, the instrument of accession expressly finds a place in Article 371 of the Constitution. The expression Constituent Assembly also finds a place in Article 370 of the Constitution. But there was a very important question which the Chief Justice has voiced on a few occasions. What is there to show that the Indian Constitution recognized the Jammu and Kashmir Constitution? I thought it was a very critical question, and I have, my lord, two answers. The Constitution does recognize the Jammu and Kashmir Constitution. May I invite your lordship's attention to the text of Article 370 itself that recognizes, my lord, that Constitution. Please, my lord, look at Article 370 with me for a moment. In Article 370, after subarticle 1, 2, and if your lordship sees 2, if the concurrence of the government of the state referred to in para 2 of subclause B of clause 1, or in the second proviso to subclause D of that clause, be given before the Constituent Assembly. And may I request, my lord, your lordships to look at the next few words. The purpose of framing the constitution of the state is convened. Constitution of the state, my lord, is no other constitution except the Jammu and Kashmir constitution. And, my lord, there is a second piece of evidence in the constitution, which has not yet been brought to your lordship's attention. There was, my lord, the state reorganization in 1956. The concept of Part B, Part C, all of them disappeared, if your lordships recollect. The Constitution's 7th Amendment Act, my lord, in Article 152, inserted the words excluding the state of Jammu.
ਕੰਨੇ ਆਈਏ ਤਾਂ ਕੰਨੇ ਆਉਂਦੇ ਕੰਨੇ ਆਈਏ ਤਾਂ ਕੰਨੇ ਲਿਆਓ ਤੇ ਕੰਨੇ ਆਈਏ ਤਾਂ ਕੰਨੇ ਆਉਂਦੇ ਆਈਏ ਤਾਂ ਕੰਨੇ ਨਾਲ ਆਓ ਤੇ ਕੰਨੇ ਆਈਏ ਤਾਂ ਕੰਨੇ ਨਾਲ ਆਓ ਤੇ ਕੰਨੇ ਆਈਏ ਤਾਂ ਕੰਨੇ ਆਉਂਦੇ